Thanks for listening to The Professional Edge. My name's Sean Todd, tax attorney, CPA, certified financial planner. So what we're talking about is estate planning do's and don'ts. In the prior sessions, we talked about having a last will and testament, making sure it's a valid last will and testament, because if it's invalid, then we're going to go distribute your estate according to the laws of descent and distribution. So if you want your state to determine who gets your property, in what amount, and when, then just sit idle and have no estate plan in force. But you and I both know that the state's plan of distribution is probably not going to be what your plan of distribution is going to be. So if you're sitting there and you have that New Year's resolution, you know what? We are already well into this year, and therefore you need to get your estate plan done. To start that process, give our office a call at 877-654-9798. That number again, 877-654-9798. So we talked about having that valid, not a download from the internet, last will and testament that is properly executed, and it is going to be valid before the probate court. That's one part of having an estate planning do. The other part is to have a durable financial power of attorney and also an advanced healthcare directive. So now let's talk about a don't. We just touched on, before we went to break, the adding of a child to your bank account to give them access to that account when something happens to you. Well, they're close. They live in town. The other child is down out of state somewhere. Could be in New York. It doesn't matter. But you add the daughter or son to that account, and lo and behold, their relationship with their spouse expires. And basically what I mean by expires is there's a divorce proceeding. Or the child is involved in an automobile accident on the way to pay their auto insurance. The policy had lapsed. They were going to make that payment, and lo and behold, they cause an accident and someone is killed. And it's your child's fault. Yes, bad things happen to good people. So now there's a multi-million-dollar wrongful death claim against your son or daughter. And you start scratching your head and you say, okay, we're all in line. We're here to help. Well, guess what? You just exposed that account to the claims of your son or daughter's creditors by adding them to the account. There's a better way. So if you've added your son or daughter to your bank account to give them access in case something happens, well, number one, you've exposed that account to the claims of that creditor for your son or daughter. That's number one. And number two, you just circumvented your estate planning document because the title on that account supersedes whatever you have in your estate planning document. So that's a big no-no. So instead of adding your son or daughter to that account, your savings account, checking account, why don't we add a durable financial power of attorney so they can step in if needed to access that account, and therefore it's not going to expose that account to the creditors of your son or daughter. That's the estate planning do. Don't add your son or daughter to your bank account. That's a big red flashing light for a listener here on the Professional Edge on what not to do. So there we go. Next, an estate planning do and don't. Well, we have life insurance, and that is controlled by a beneficiary designation. And you know what? That right there also supersedes whatever we have in our estate planning document. Now, we can always get it into and be controlled by our estate planning document, being the last will and testament or the living trust, by designating the designated beneficiary on that policy as being the estate of Bill Smith or the living trust of Bill Smith. Now that says the insurance company is going to get a phone call and they're going to say, yep, Bill Smith passed away, and here's the copy of the death certificate. And lo and behold, the beneficiary designation is the estate of Bill Smith. Therefore, it's going to be controlled by the terms of that last will and testament, which is fine if we do some advanced estate planning for those proceeds, because we got to remember a lot of our listeners here on the Professional Edge have never received a $500,000 check in lump sum that's not taxed, because we all know that life insurance is not included in taxable income. So it's all spendable. So we take that into account and we say, okay, when would we want to name the estate or the trust of Will Smith as being the primary beneficiary on that life insurance policy and not outright to the surviving spouse? Well, if the surviving spouse is not that attuned or accurate in financial planning decisions, investing, things like that, then within that last will and testament or the revocable living trust, we may want to have established for the surviving spouse that's not financially literate, which is okay because not everyone is. And that can be for the guy. I mean, the wife could be the one handling the finances, and she puts him on an allowance. And you're looking at each other right now, knowing who this applies to. You give him his $100 and he's broke by Tuesday, and you handed it to him on Monday because he spends everything he gets. So that's one of those situations. So what we do is that $500,000 life insurance policy is paid to the estate of the decedent via the last will or the revocable trust. And within that document, then we say, hey, for that surviving spouse, we're going to place this money in trust for them. So they cannot just blow that money. And therefore, that money is available to them. And we assign a financial advisor to that trust share. So now we have a financial advisor assigned to that trust to make sure the spendthrift surviving spouse is not going to spend all of that money and fritter it away. Now, with that, we can also say that the surviving spouse can receive, $2,000 a month or $5,000 a month, whatever is appropriate. And therefore, if there's a large expenditure, let's say a new roof is needed or a new car is needed, then we can access the principal of that trust and also protect that surviving spouse from frittering that away, having a spendthrift surviving spouse. We all know if we got one, and you just look at each other right now with a little wink in your eye and say, yeah, you are that person he's referring to. So if that's the case, then we make that beneficiary designation on that life insurance because we know the beneficiary on that life insurance supersedes whatever we have in our estate planning document. But if it's a coordinated plan, and that's where working with a tax attorney, a CPA, and a certified financial planner, which I'm all those individuals combined in one person, then it's all coordinated. Your estate plan is done. A lot of attorneys that don't do estate planning don't understand financial instruments. They just draft a last will and testament. They say, okay, great, all to your surviving spouse. If they don't survive, it's outright to the kids, equal shares. Have a nice day, press hard, yellow copy's yours. Well, that's not an effective estate plan. That is one of those estate planning don't. If you have multiple financial instruments, that could be life insurance, that could be IRAs, that could be brokerage accounts, that could be real estate, that could be real estate outside the state of your domicile state, then you need a competent estate planning attorney to assist in your estate plan. It is a viable, very beneficial exercise to have that to avoid contests in estate plans. So again, to start that conversation, do give our office a call at 877-654-9798. That number again, 877-654-9798. And for listeners here on the Professional Edge, here's a super bonus. It's an inflation buster. It is probably the best money you will spend for value-wise that I can think of. I have drastically reduced this because it combines your estate plan, your financial plan, and then your tax plan. We just got done with having our taxes done. And to plan your taxes is not when you're preparing your tax return. It's now. So we plan our taxes all throughout the year to have a great result when we do file our income taxes. And that bonus offer is available to you if you go to the website emcthebundle.com. That is Echo Mary Charlie thebundle.com. So take advantage of that because that gets things in force, in place. It's a fixed fee. Yes, I've done this enough. I know the value that you're receiving if you would get these three separate items, your estate plan, your financial plan, and then your tax plan. It would be well north of 10 grand in fees. I've dropped this to incentivize you as a listener here on the Professional Edge to get your estate planning done. Yes, that is a New Year's resolution to get your estate plan done. Take the action step to get this in force, in place. It's not going to be wasted dollars because, again, we have not discovered the fountain of youth. So, again, that website is Echo Mary Charlie, emcthebundle.com. So, back to estate planning do's and don'ts. We have this don't add your kids to your bank account. That's number one. The provision or the beneficiary designation on your life insurance supersedes whatever you have in your estate planning documents. So the do is coordinate that with your estate plan, and we might want to have it as the estate of the decedent to be the beneficiary because the dispositive provisions within that estate planning document is actually going to protect the surviving spouse from themselves. Okay, so that's an estate planning do. Don't leave this outright to the surviving spouse who's very young. Let's say this is a second marriage and you designate your surviving spouse as being the sole beneficiary of this $1 million life insurance policy. And the thought in the back of your mind is, hey, you know what? I want this to make sure my surviving spouse is going to be well taken care of. But then if anything's left over, I want that to go to my kids of my first marriage. Okay, that's all well and good. But you know what? An estate planning don't do that, because once you leave this out to the surviving spouse outright, they have no legal obligation to leave the remaining proceeds to your children. Again, I'm going to repeat that. They have no legal obligation to leave that to your children when they pass away. They can leave it to anyone they want. So an estate planning do control that via a trust in your estate planning document. So more coming up here on the Professional Edge. My name's Sean Todd, tax attorney, CPA, and certified financial planner, host here on the Professional Edge for 5+ years.
We've all thought about it. Everyone listening will need one. Not having one can cause untold heartache, family conflict escalating to the point of a lawsuit. One simple thing that avoids all that: an effective estate plan. As a practicing tax attorney, Sean Todd with Estate Management Counselors has completed over 1,000 estate plans during his 15 years of professional practice. He can help you implement an effective estate plan, coordinate your financial accounts, and make sure you have named the proper beneficiaries to maximize your tax savings. Call 877-654-9798 today and let tax attorney Sean Todd help you implement an effective estate plan. Call 877-654-9798 today. As a tax attorney, CPA for over 15 years, Sean Todd has implemented over 1,000 individual estate plans. He has recently authored an especially helpful guide, How to Unlock the Ultimate Estate Plan. This guide has helped many individuals to understand the benefits of an estate plan and how to avoid unintended disasters. Sean has made every attempt to write this in plain English. To receive this valuable guide, How to Unlock the Ultimate Estate Plan, call 1-877-654-9798 and request your complimentary copy today, or by emailing your request to info@emcadvisors.net.